This
Cool.
conference will now be recorded.
Okay. Thank you all for joining us this evening for the Public Oversight Committee's last meeting before we begin field work at Oak Lawn Cemetery on June 1st. The Public Oversight Committee was established to ensure transparency and community engagement throughout the 1921 Graves investigation. The committee serves in an advisory capacity to the city during key decisions throughout the investigation. The Oversight Committee is comprised of descendants of the Tulsa Race Massacre and leaders in Tulsa's African American community. At the request of the Public Oversight Committee, this evening we have a guest speaker, Bill Kellow, attorney and former Tulsa County presiding district judge. And by the end of our time together, we will receive information and have an opportunity to ask questions about criminal prosecutions related to the 1921 Race Massacre. Chair Cavan, do you want to start with our introduction? I should have said our welcome.
I like to, yeah, that's me. I like to welcome one and all attending this last meeting before we go on this historic journey. The calls, the visits of reporters, and just the everyday people just coming to asking questions on how we're going to go through this process and how they're watching us. And most of that's coming from the young folk, which I'm very proud of, because we too are all sharing what happened in our past to make a better future here in Tulsa. And I'm so glad that we're on the right track, we're at the right time, and we're moving forward despite our differences. But we got a lot of commonalities that will just erase those differences. I'm glad that we had a point in Oklahoma history and Tulsa history, and especially in American history, that the whole world's watching us as we go through this process to make life a better place in the future. It's been said that we cannot control or change the past, but we do have the power to change the course of our future. I'm often reminded by the phrase of the late Dr. John Hope Franklin in our many meetings that when he would come to Tulsa, and he always would tell me that embrace the past, study your history. You will be better prepared for your destiny because history has a way of repeating it. And this time on our watch, I'd like for all of us focus on the mindset of let's make a new and brighter history. Reverend.
Thank you, Chair Ross. We will turn it over to Reverend Turner to provide tonight's invocation.
Dear God, our Father, in the name of Jesus, we pray to you, we bow before you, we prostrate ourselves in your presence. We ask that you cover us with your grace and give us your wisdom. Continue to lead and guide us. Bless the members of this committee. Bless our elected officials who are on the call. Bless even those of the media. We pray that the words of our mouth and the meditation of our hearts be acceptable in thy sight, O Lord, our strength and our Redeemer. Amen.
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 Thank you, Reverend Turner, for those words. While we're waiting for another member of the Physical Investigation Committee to join, we're going to go ahead and move forward in our agenda to item 4, our presentation and discussion regarding criminal prosecutions. And I will turn it over to Bill Kellow.
Okay, there we go. Thank you, Amy and Reverend Turner and all of you for the opportunity to speak tonight. It's really an honor and a privilege. You are doing important work in the community. Everyone knows that. And I want to applaud your efforts and commend you on being very thorough in your investigation of everything that went on in those terrible days in 1921 and the consequences of those events. You might need to forgive me a little bit for reading from time to time from my prepared paper, if you will. The topic tonight is too important to be extemporaneous. I really wanted to present this thoughtfully and somewhat methodically, so that I will have to refer to my script every now and then, but it doesn't detract from the commitment I have and the feeling I have about this process. We all know that the Greenwood community suffered death, personal injury, and catastrophic property damage. And the primary perpetrators, as we know historically, were thousands of armed white vigilantes. But history also tells us that the city of Tulsa, Tulsa County, and possibly even the state of Oklahoma had a major role in facilitating the massacre and the destruction which took place in May 1921. But specifically, as I understand it, tonight, I'm to talk to you about this question: can the city of Tulsa, Tulsa County, or the state of Oklahoma be held criminally liable for the loss of life or property damage caused by the perpetrators of the 1921 Tulsa Race Massacre based on the conduct of its elected agents, employees, or deputies? And I am going to address that specific question. I want to be clear on what I'm not attempting to present tonight or give you an opinion on. My discussion tonight is on criminal liability, charges that could be filed, arrests made, trials conducted, sentences handed down. There are other attorneys I know working on the question of civil liability, and that actually has been a question that's been in the courts for nearly 20 years in one form or another. And it isn't my intention to go off into that area. I think that it's better that I leave the subject to those who are most familiar with it and are researching it and presenting it now. Another comment I want to make, which is just an aside, but it's an interesting one, and that is the effect of the recent McGirt versus the state of Oklahoma case, which many of you, probably all of you, have heard of. And you know that it establishes federal and tribal court jurisdiction over certain crimes committed in historically Native American tribal land, which would include the Greenwood area. But the big limitation which is provided in McGirt is that the crimes themselves must have either been perpetrated by a member of one of the tribes or against a member of the tribe as a victim. And to my knowledge, and there may be historical records on this, but to my knowledge, there isn't any evidence of tribal connections involving either the perpetrators or the victims. And so I'm not going to address the federal law or tribal law potential jurisdiction issues over these crimes. I also am not going to delve into the evidence. I mean, when you talk about criminal charges, prosecutors have to know what the evidence is. They have to know the identity of individuals, what they did, when they did it, and there's a whole range of issues that have to be established before someone can be convicted of a crime beyond a reasonable doubt. But I think it's fair to just simply say that we're going to take it for granted that evidence could be established and identities established as to perpetrators and victims, and that could be done, and I'm going to take it for granted that it exists for purposes of my discussion tonight. And finally, I want to make this comment that due to the fact that it's just simply impossible that any individual perpetrator or aider and abetter of these crimes currently is living. We'll have to just take that as a given. So my discussion really has to do with basically what we call in the law vicarious liability for criminal conduct of other persons who can't be charged with the crimes, and they simply can't be because they're deceased. Just a bit of an aside, as a personal matter, who am I? I am a former district court judge on the bench for 8 years. I was assigned a felony docket from 2007 to 2015. I've written on the subject of the history of the federal courts in Oklahoma, and I have read a number of accounts of the Greenwood race massacre. I think the first one was by my old friend Danny Goebel, who was a historian at the University of Oklahoma in 2004. The first time it was just laid out for me. But in my practice on the bench, or in my tenure on the bench, I handled nothing but felony cases, and I tried approximately 155 jury trials, most of which involved the kinds of crimes we're talking about today. Currently, I'm very much involved in a very, I think, interesting and impactful nonprofit organization, which I helped co-found, called the First Step Male Diversion Program, which is just in short is attempting to break the school to prison pipeline for a number of young men charged with nonviolent felonies. But you don't have time to hear about that tonight, but I love to talk about it. So let's start with just the basic facts, and that is the nature of the crimes that were committed. From all historical accounts, there were numerous criminal acts which were perpetrated not only by the civilian white mob, but also enabled, incited, and with some participation by City of Tulsa, Tulsa County, and even possibly the state of Oklahoma officials and employees. Historical accounts and the Tulsa Race Riot Commission report in the early 2000s concluded that there was no doubt that white Tulsa officials were largely to blame for the massacre. They not only failed to prevent the bloodshed, but had also deputized white civilians who took part in the burning and the killing. And of course, it is the bedrock of our criminal justice system that all persons accused of crimes are entitled to due process of law and the presumption of innocence. But again, for purposes of this discussion, we can all assume that the employees, that is the legal agents of those government entities, acted within the scope of their duties and caused, in many instances, the death and destruction of an entire community of African American citizens of Tulsa. Some of the more serious crimes committed, again from the historical record, were certainly murder in the first degree and other lesser degrees of murder, manslaughter and various lesser degrees of manslaughter, shooting with intent to kill, assault and battery with a deadly weapon or a dangerous weapon, simple assault and battery, and on an unbelievable scale, arson. These are all terms which, of course, have statutory connections and citations, which I'm not going to give you tonight, but I can certainly provide them. So let's start first with the big picture issue of homicide. Homicide is defined as the killing of one human being by another human being. That's a simple definition. There are varying categories of homicide, such as first-degree malice murder, that is, murder with malice of forethought or intention. Second-degree murder, which is killing an individual without the specific intent to do so, but with reckless disregard of that person's safety. Death resulting from the commission of a felony. So, for example, an act of arson, which results in someone dying, would be a felony murder, a first-degree murder. Various types of manslaughter, which again are not intentional acts, but reckless and negligent acts causing the death of another person. All of the crimes that I just enumerated have one thing in common, and this is the important point that I have to make tonight. They require a live human defendant for there to be an action by the state of Oklahoma in prosecuting those felonies. In more specific detail, murder in the first degree carries a life in prison or life without parole sentence or the death penalty. And that goes along with the felony murder cases as well. Murder in the second degree, the sentence is 10 years to life. Manslaughter in the first degree is 4 years to life. Shooting with intent to kill, the sentence is up to life in prison, starting at 0 and up to life. Assault and battery with a dangerous weapon, and that's any weapon other than a firearm, up to 10 years. Assault and battery with a deadly weapon, which means a firearm. Typically, it could mean a knife. That's up to life in prison. Arson in the first degree, which involves intentional burning of an occupied dwelling, the sentence is up to 35 years in prison. And I could go on and give you more details on all of the conceivable crimes, malicious destruction of property, which is a misdemeanor, and so forth. So we know crimes were committed on a large and almost unprecedented scale. The question is, who can be held accountable today? Well, as I said earlier, obviously the perpetrators themselves, any one of whom living today could be prosecuted, just as we saw prison guards at Auschwitz, 90 years old, being tried in courtrooms in Germany. The same thing could happen here for murder. Now let's talk about why I'm really here, and that is to discuss the criminal liability of either the city, the county, or the state. The city, the county, or the state obviously cannot be imprisoned. There is no mechanism for doing that, and the criminal justice system of the United States, and maybe not in every jurisdiction in the world, but certainly in the United States and the Anglo-American system, does not allow for persons to be punished for crimes which they had nothing to do with, whether the crime was committed by another person, business, company, or governmental entity. In other words, the state of Oklahoma today, or the federal government, if it was a federal crime, could not prosecute a person for committing a crime which was committed by another person. unless that individual was an aider and abetter of the other person. These are just bedrock principles of law. Oklahoma law provides that all persons are capable of committing a crime. And I'm going to get to in a minute the divergence of types of crimes which can actually be committed and therefore be punished by entities other than persons. But as you can just tell by, let's say, common sense, the acts that we just discussed of physical violence and arson and assault and battery, murder, those are crimes which can only be perpetrated by an individual human being. Now, business entities such as corporations and certain types of limited liability companies are certainly liable for certain types of criminal misconduct. Obvious examples, and I had personal experience with one myself, just a bit of a diversion. In my early days as an attorney, I assisted in not the prosecution, but the aftermath of a prosecution of two offshore oil companies who conspired to violate antitrust law. The two companies, and these were listed Fortune 500 corporations, were charged by a grand jury with criminal antitrust violations for fixing prices, essentially. And they were liable, of course, for only a civil fine. Excuse me, let me back up. I misspoke. A fine, not a civil fine, but a fine, a criminal fine. And indeed, that's what they did to resolve their criminal charges. None of the individuals within those companies was facing any kind of jail sentence, although they might have been if they had been active participants and there was evidence to support it. But the government chose instead to go after the companies themselves. Another example of businesses which can be subject to criminal liability are those that intentionally violate environmental law, creating environmental hazards, dumping poisons into watersheds and so forth. There is criminal liability for certain environmental crimes. And those again result, if successful and if convictions are obtained, in fines and not the company itself being incarcerated, which again is just simply an impossibility. So now I've talked about the exposure of companies, corporations, and limited liability companies for criminal violations. What about government entities? Cities, states, counties. Can those entities, and they are that, be charged with criminal misconduct? And I think, and I'll have to be lawyerly in saying it, I think that the answer is yes. There's very little case law dealing with criminal liability for cities, counties, states, and there are no Oklahoma cases on point that I'm aware of. But it's logical to assume that such liability exists for criminal misconduct because they are, municipalities and counties, states are liable for civil damages for violating civil rights. Those cases are filed all the time. They result in an amount of money owed for action by these by governmental entities which cause damage to individual plaintiffs and verdicts and are awarded fairly often against municipalities and other government entities for those kinds of wrongs committed in a civil context. In my opinion, it's possible to extrapolate from that if a charging party, for example, a prosecutor, federal or state, wanted to file criminal charges against a government entity for the kinds of violations I mentioned earlier, such as intentional pollution or antitrust law, I don't know that there would be any reason to prohibit that. But again, the ultimate result would be a fine and not any form of incarceration for the entity itself. The crimes that relate to the Greenwood massacre are not, in my opinion, the kind of crimes that governmental entities are able to commit. They don't involve these kinds of violations of law which are on the books but have no physical or acting responsibility by individuals. These are crimes that I've discussed that are violent, personal actions by individuals. No government entity can commit those crimes. Cities do not commit arson or murder or destruction of property. But again, to the extent that any person was today still living and that person committed any of these crimes, then that person could be charged, and I've said that. There is one last area to explore, however, which I think has not really surfaced in any of the discussions I've heard, that is interesting and perhaps could be further explored by those who have the time to pursue it, and that is the law of conspiracy. What do I mean by that? Well, there is a statute in Oklahoma that says essentially that two or more persons, the term is persons, can conspire to commit a crime under Oklahoma law. And if that is established, then both individuals, both persons, and I'll get back to why I'm emphasizing that, both of the persons can be convicted and sentenced for criminal conspiracy. It's 21 Oklahoma Statute, Section 421, if anyone's interested in pursuing that. The crime is a separate crime from other crimes. It's in and of itself. It's the crime of conspiracy. And the public interest is at play because it's in the interest of all of us that crimes not be committed, but it's especially of importance that individuals don't get together to conspire to commit a crime. So there is a criminal penalty involved, and it's $5,000 as a maximum fine, which I'm sure hasn't been adjusted by the Oklahoma legislature in decades, and up to 10 years in prison, or both a fine and imprisonment. Now, the term person is not defined in this particular statute, but in other areas of the law, the term person has been interpreted to mean a corporation or a business entity that I mentioned earlier. So it is established, and there are a number of cases that hold that a company, a corporation, a business entity can in fact conspire with another company or an individual, and that creates a legal, actionable conspiracy. I have a couple of cases that I can cite to you on that. One involved General Motors, and there's a state of Oklahoma case even on that point that establishes that A corporation or a business entity can be indicted as a conspirator. So again, based on my earlier extrapolation, there isn't any reason, probably cautionary there, why a government entity could not also be charged with a conspiracy to commit a felony along with a person or persons, in the case of Greenwood, such as a deputy sheriff or a police officer. So analysis is City of Tulsa, individuals either associated directly with the city or not, enter into an agreement. It doesn't have to be very formal, an agreement to commit a crime. And then they act in furtherance of that crime. That creates a crime in and of itself, independently of the crime which they're attempting to initiate, which in our case would be violent acts. That's a conspiracy. I won't pretend to say that I found any case law supporting it or statute directly on point, but it's you're here to, I'm here to tell you what I think is possible and to explore the entire waterfront of what you're talking about. And that's something that I think is supportable. Another important point in conspiracy law is that just because one of the conspirators was incapable of committing the independent crime doesn't mean that person can't be charged with the conspiracy to commit the crime. I know that sounded extremely complicated, and I apologize, so I'll say it again. If you have two entities, a person and a company, let's say, or let's just even go on further and say the county, enter into a conspiracy to commit heinous criminal activity in Greenwood, and they entered into that agreement. Again, as I said earlier, the county, the city, the state are not capable as a matter of law and common sense to actually do anything. They're just entities. They just exist on paper, essentially. But that doesn't prevent them from being charged as a conspirator. And there's some case law supporting that proposition as well. Now, as I said, the charge is 10 years in prison, maximum $5,000 fine, maximum. Once again, the entity that we're talking about, the city, the state, or the county, cannot be incarcerated, cannot be punished, cannot be subjected to any kind of actual physical punishment. So the fine only would apply to that particular member of the conspiracy. I'm going to conclude, however, with what I think is a extremely important point, and it's one which I think I have to say is sort of a bookend to everything I've been saying, and that's the statute of limitations. I think it's pretty much common knowledge that there is no statute of limitations for murder in the first degree. Arguably, there is for second degree, but I question that. I think that murder in any form is subject to no limitations. If someone were found to have committed a murder in 1921 and still was alive, that person would be subjected to a charge of murder in the first degree. But that's the only criminal act that has no statute of limitations applicable to it. For arson, for example, there's a 7-year statute of limitations. And of course, you understand I'm talking about 7 years from the date of the commission of the crime to the date of the filing of action against the person committing the crime. 8 years after an arson is committed, 9 years, 10 years, 100 years makes it legally impossible to charge that person with the criminal act. Now, since I've introduced the concept of a conspiracy, which is, again, a separate crime that could exist, I need to bring us to the final conclusion on that one as well. And the statute of limitations for all felonies other than certain enumerated felonies, arson is one, shooting with intent to kill is another one, in which there's a 7-year statute. All other felonies have a 3-year statute of limitations. And this is in Title 22, Section 152 of the Oklahoma statutes. So we're faced with the situation that the charge of conspiracy would have been barred and would have been unable to be pursued after 3 years after the commission of the conspiracy and the actions that took place in furtherance of the conspiracy. Now, I don't want to go too far down this road, but I want to show you that there are limits to the statute of limitations that could be argued. And there is one particular limitation involving sex crimes involving children, in which there's actually now an Oklahoma statute which says essentially that during a time when a child is a child and growing up and so forth, if that individual has been sexually molested, the statute of limitations doesn't begin to run until adulthood, and even thereafter. There's different variations on that. In other words, there's certain types of crimes that the legislature said are too hidden from everyone's view that they should not be subject to a statute of limitations that dramatically prevents a filing of a charge. That's not something we can say, unfortunately or fortunately, about the Greenwood massacre that occurred. It was well known and not hidden. There's no argument to be made, in my opinion, that the statute of limitations should be suspended. So I'm left with the following conclusion, and I'll read it to you because I think I tried to make every word count. No one is alive to be prosecuted for the many crimes against the residents of Greenwood. The law does not allow for one person to stand in and be punished for the crimes of another person unless that person was an actual aider or abettor. The city, county, and state of Oklahoma are government entities and obviously cannot be imprisoned or subjected to any type of physical punishment. They can be fined, and often are, for state and federal crimes involving such things as antitrust laws and environmental laws, for example. In theory, the government entities in the Greenwood case could be considered as co-conspirators, along with the persons who committed the acts. Since these crimes of violence, they fall under the jurisdiction of the state and not federal law. And I said that earlier, despite in the McGirt case, which establishes federal and tribal jurisdiction. Conspiracy to commit a felony is a crime punishable by both a prison sentence and a fine. The city, state, or county could be charged as co-conspirators. However, in my opinion, a statute of limitations for conspiracy, which is 3 years from the date of the commission of the crime, would prevent charges being filed, arrests made, and trial proceeding against any person. So therefore, in my opinion, there are no criminal charges possible today for the Greenwood race massacre. I want to reemphasize that this does not preclude the possibility of money damages again, with all the limitations issues on statute of limitations, but nonetheless, I wouldn't want to give anyone the impression that I'm suggesting that those cases have no merit. And I believe there is actually one case that has been filed within the last year. So that really concludes my comments, and I'd be happy to answer your questions.
Thank you, Bill. We'll allow members of the Public Oversight Committee to unmute and ask their questions, or if you're more comfortable or would prefer, you can also place those in the chat. We know that was a lot of information, so any questions to clarify or cover something that maybe wasn't mentioned?
I just had one clarifying question. This is Greg Robinson. Thank you.
Thank you.
Thank you, Attorney McCullough. Hello. My question is actually referring to something you said just very early on around the tribal sovereignty question. And I wanted to bring up the fact that obviously there were freedmen, many of them in the area with freedmen allotments, and based on federal law, they were granted citizenship at that time. And so I just wanted to bring that up and try to get some clarity around that. Not that we have to adjudicate it or anything, but that was, there are plenty of folks who were freedmen of the Creek Nation, as well as the other tribes that would have been in that area at that time.
Yeah, I appreciate hearing that, and I would say that just because of my kind of limitation of time and focus, I didn't spend much time researching the federal and tribal law applicable here. In general, federal law does have the equivalent of many of the charges that we were talking about under state law. There is a federal crime, murder, and violent actions, arson, and so forth. And they've been around for years because even before McGirt, crimes committed on recognized tribal land, for example, casinos, were prosecuted in federal court. And so McGirt, all it did was expand the footprint, basically, of the jurisdiction that the federal courts had already assumed. And they have been filing major crimes charges for decades. I won't say this definitively, but I think that it's likely that the same analysis that I went through for establishing who would be responsible for criminal misconduct as individuals versus companies and versus government entities would probably apply to the federal law as well. Tribal law is limited to essentially misdemeanors, at least historically, and crimes involving jail sentences of 3 years or less. And so they don't really approach the level of seriousness of the crimes that we've been talking about. So I guess I'll leave it this way and say that it's possible that there would be case law in the federal system that would maybe could be analyzed to look at the rights of individual freedmen who would be entitled to the McGirt kind of protection, which could change my analysis, but I'm inclined to think that it won't. I'll just have to leave it at that.
I had a question. Thank you for inviting him to the meeting. Amy, I've been really asking about the criminal investigation for a while, and I'm happy to see. And Judge, thank you for your time. I have a few questions. The first being, who initiates? Who can initiate this? So, for instance, if I was robbed, I go and file my own police report, right? In this case of the 1921 Tulsa Race Massacre, who initiates and who is the entity we make that initiation with? And can you restate that statute again?
Well, I really did never cite that particular statute. What you're talking about is who the state of Oklahoma is authorized to prosecute felonies. Okay, and every crime I've been describing is a felony. Cities cannot prosecute felonies. Now, again, as Mr. Robinson indicated, the federal government can and is prosecuting felonies involving tribal relationships. But so the state has to file it. The state acts through the district attorney. There isn't any other entity other than the attorney general in certain cases where the district attorney recuses, that is, decides that it cannot proceed. The attorney general of Oklahoma can actually file criminal charges. But the initial action, you're right, the typical case goes with a police report or a police investigation of a crime to the district attorney, and the district attorney has to make the decision. Now, there is also another avenue, okay, for charging crimes, and that is through the grand jury. And when I was on the bench, I actually had 2 grand jury cases in which the district attorney declined to file. None of them involving anything like these cases, but they were, for one reason or another, the district attorney said, I'm not going to file charges. And the opponents that wanted to see charges filed gathered signatures, and I believe it was 5,000. It may have changed, but that's what I recall. And that actually results in the convening of a grand jury presided over by the presiding judge of Tulsa County. And the grand jury investigates and determines whether a crime has been committed. And they have the right to indict an individual for crimes. And so that's the procedure that you go through. Either the district attorney, or if the district attorney declines to file, and if there's merit, then now the judge finally has the final decision on whether a case can move forward. Just because 5,000 citizens sign a petition doesn't necessarily mean it will go to a trial. It still requires the judge to agree with that. But I think that answers your question.
Yeah. So unless the DA starts an investigation, none of this will ever be done, or the attorney general.
I wouldn't say that. I mean, for one thing, investigations are really not started by the district attorney. Investigations are started by police or law enforcement. So the party, the player in this situation that would have to get the ball rolling for a crime to be considered would have to be either the city police or the county sheriff, if the attorney general got involved, they use the OSBI, which is the Oklahoma State Bureau of Investigation. So you've got kind of 3 law enforcement entities out there that would look into this, and then they develop the case, the facts, and who do we charge, what did they do, and then that's delivered to the DA's office, and then the DA decides, am I going to proceed to charge or not? So the investigation comes from other than the DA. It comes from law enforcement.
And so, who can make that request to the police?
Anybody.
Okay.
Anybody. I mean, you can always just ask that an investigation be conducted.
Well, I have.
Well, yeah, I bet you have. The only other entity that, again, could conduct that kind of an investigation that isn't local would be through the Attorney General and the OSBI. But one of the first things that law enforcement would do would be to look into who could be charged. And that's, kind of what I've been addressing tonight. It's an important question. And if it can't be determined that there's anyone living or any entity capable of being charged, then law enforcement isn't gonna move it.
Judge, thank you so much for your time and
Thank
your
you,
information.
Reverend. Thank you very much.
Judge, I got a question that always haunted me, and you probably clarified it already. And if I'm redundant, please forgive me. We do know that there were entities that deputized the mob via the city or the sheriff's department, who basically turn a mob. These folks who are supposed to be deputized arms of the law that end up turn out being an armed mob. Isn't the city or whomever gave that permission or deputized this group, aren't they responsible for this? I know there's some mention in the Tulsa Race Riot Commission report that was filed in 2001, as they cite and sought to find blame in those who committed that. But it always been a wonder in my mind, especially when the Supreme Court wouldn't even hear the case because it's dealing with statutes of limitation. And I was of the belief that the statute of limitation, when it comes to murder, is no limitation on murder. And could you clarify for somebody that pretty much everything you said went over their head?
I appreciate that, and I have to apologize for the fact that I read this and it probably sounded a little bit like I was reading.
No, you said fine.
I understand. Well, let me just say that the second part of your question first, and that is what happened to the lawsuit. And I think you're referring to a lawsuit that was filed in federal court in front of a judge who's no longer alive, named James Ellison, the federal district judge. And that case was called, I don't have the name of it. I can't recall of the specific parties, but I know that some rather well-known attorneys from, I think Johnny Cochran was involved. There were some lawyers that came in and filed this lawsuit, but it was a civil action. It was not a criminal case. It was a case in which, they were seeking the plaintiffs, the named plaintiffs, kind of people like yourselves in the position. I think there were actually a number of living people that had lived through the Greenwood massacre at that time, who were the plaintiffs, and they were basically they filed a lawsuit, and the judge determined that the statute of limitations had run. It wasn't the federal government or the state charging anyone with murder. That would have been, like you just said, not subject to a statute of limitations. But when you have a civil action, then the limitations argument can be made. And again, I'm not an expert on that case, but I know it's out there. I see Mr. Ellsworth maybe know more about it than I probably do.
Well, I was just going to say it was filed by Professor Charles Ogletree of the Harvard Law School. I think it was in 2003. I can't remember the exact date. It wound its way through the federal court system. It was on behalf of, I think, something like 140 living survivors at that point. It made it to the United States Supreme Court, but the United States Supreme Court would not hear the case.
Yeah, it went through the 10th Circuit, where they affirmed the district court, and then it stopped at that point. But
it was a split decision in the 10th Circuit, as I recall.
Yeah, and I know that Judge Ellison's opinion, as I remember reading it years ago, he said, "I regret having to do this," because he understood that it was depriving these individuals of their and these were actual victims, personal victims of their rights. But he applied the law as he saw it. But Mr. Ross, I guess I would say that the wrongs were committed, and there are moral issues and there are legal issues. And I am just simply applying what I think is the kind of the black letter law that would prevent a prosecutor from going out and saying, okay, I'm going to charge the city of Tulsa with a criminal act. We know that as far as deputizing, yes, I think there is clear evidence that the county, I guess it's the county really that deputizes deputies. That's the whole nature of what they are, deputy. And that did absolutely occur. But again, the entity itself can't be subjected to imprisonment. And the people that were responsible, the sheriff or whoever participated in that, clearly could be, but they're all deceased. And that's my point. But it doesn't, there's a different picture painted if you're talking about civil liability. And there is a case proceeding right now that I believe is in state court, in which civil liability is being sought, and that argument is going to have to be presented to a judge and maybe a jury in Tulsa County.
And so since the sheriff was acting on the behalf of the county, so
Yeah.
you're saying that the county can be held liable for the actions of that sheriff, which I find out that he was charged with some negative behavior, Sheriff McCullough.
I think that the argument of conspiracy is there that I was talking about, the action of an entity being the county, right? And the sheriff himself and the other participants, the mob, entered into a conspiracy. And so I'm not saying that's not possible. I'm just saying that the statute of limitations now has to be looked at. And that's where the 3 years comes in. And I have no way of figuring out how to overcome that. I'm not here to advocate for anybody. I'm just here to just present the law as I would see it. If I were on the bench and this case was presented to me and the district attorney said, I have a case against Tulsa County for conspiracy to commit acts of violence in 1921. If I want to apply the law, I would have to say there's no claim could be presented. Anyway, are there any other questions?
So the way that the way that Professor Ogletree and his team of lawyers tried to get around the statute of limitations was to say that it was until the publication of the Tulsa Race Riot Commission report in 2001, it was only at that point that the survivors had a full accounting and a full knowledge of the crimes that were committed against them, and that would allow that the statute of limitations should not have started ticking in 1921, but in 2001 with that report. And that was a legal hurdle that team simply could not get over.
Yeah, correct. And now, unfortunately, another, almost 20 years has gone by to make that argument even less persuasive, I think. So that's my presentation. I've probably taken up more time, Amy, than you allotted. So I guess you'll just have to run the meeting a little later.
Bill, we just want to thank you so much for the very methodical way you walked us through that. It's very helpful. And thank you also to the Public Oversight Committee members who asked questions and shared information. We're going to go ahead and move now to our update from our Physical Investigation Committee. Carrie is going to provide a quick update on how we're moving ahead towards June 1st, and then Rodrigo is going to speak briefly about signups for cultural monitors. So Carrie, I'll let you go first.
Good evening, everybody. It's great to be with you this evening. Just to provide a very quick update, we are on pace to begin the next phase of excavation and then exhumation as of June 1st. And as of today, we completed interviews with some of the consulting firms who had submitted proposals. and we are very close to selecting one of those firms to assist with this effort to make that process so we can expedite that process and make sure that we have an adequate number of people out there to complete that effort. So that's just basically to say that that's kind of where we are right now with that. And I think unless there's some additional questions, or Amy, unless you had some other topics you wanted me to cover on that, that's just, I think that's the main thing I have to report at this point in time on that phase.
Thanks, Carrie. I think maybe we'll let Rodrigo speak about our cultural monitor process, and then maybe we'll open it up for questions from the Public Oversight Committee.
Great. Good evening, everyone. Yeah, so I'm just going to share just briefly that that we would like to ask members of the Public Oversight Committee if they would be interested in signing up and serving as cultural monitors as we enter this this next phase with the field work at Oak Lawn Cemetery. And really our hope is to have about 1 to 2 cultural monitors on site for each shift, basically overseeing what's going on, consulting in the decision making, and really ensuring that things are being handled with respect and dignity. And so I'll be sending an email with a link to sign up to the Public Oversight Committee. But just so you know, the shifts that we will be looking at will be there will be a morning shift and an afternoon shift. So the morning shift will be from 7 to 11, and then the afternoon shift will be from 12 to 4 p.m. These would take place Monday through Friday from June 1 to July 13th. And so you can sign up for an AM or PM shift on the same day if you'd like as well. So so that's just some general information there. But as I said, I will be following up with an email to the Oversight Committee for you all to sign up this week. Thanks.
Thanks, Rodrigo. Are there any questions from the Public Oversight Committee about that update? No significant changes since we last spoke, but just wanted to confirm with everyone that things are still on track.
And Amy, it occurs to me, maybe I can share just a little bit more about just some of the basic steps, so maybe people have a sense of what to anticipate for how we're expecting this next phase of the excavation work to unfold. Basically what we'll be doing is to start first with bringing the backhoe out to remove the overburden. That's that upper few feet of soil that is laying over the coffins. And we're going to not expose the entire mass grave all at one go. We're going to be doing it in segments. And so we'll start with one section where we can expose the coffins and get down to a level that basically like what we did in October, where we removed the overburden, got to that point of just exposing the top portions of the coffins. That's the point at which we would then shift over to conducting our excavation work by hand, and very carefully, thoughtfully, and methodically to ensure that we can capture as much information as we possibly can during that excavation process, and so that we can document it appropriately. The expectation is then that we will expose the remains in place, and basically what we call it pedestaling them. So we will remove the soil around the remains themselves, but leave them in place so that we can accurately document them through mapping and photography and copious note taking, so that we can make sure that we document them to the best of our ability while they're in place. At that point in time, then those remains, once the adequate documentation is completed, then we would remove those remains, and those will then go to the next phase, which would be the analysis that's going to be undertaken by Dr. Phoebe Stubblefield and her team of the physical anthropologist who will be conducting the osteological analyses. So that's a very broad overview of the main steps that will be taking place. We will also be screening the soil when it gets to that very careful stage of excavation, that careful hand excavation process. We will be screening the soil just to make sure that we don't miss anything in that process. So that's just to give you kind of a broad sense of the variety of activities that will be taking place over the course of those next steps in the investigation.
I have a question. What is the time frame? I know in the early excavations, both in July and August, there was a painstaking, slow process that just inch by inch, getting down to the bottom areas of the trenches. At what pace are we going to? Now we know that they are there. Are we going to still take those smaller steps to get to the point of where we need to be to return to the spot where we once was? And also, I did not hear Rodrigo I heard the first day. Could you repeat those dates where you're gonna need witnesses there on the gravesite? On my end, start breaking up at the end of the dates that you need folks to be there.
Yeah, sorry about that, Chair Ross. Yeah, so we'll be looking Monday through Friday. Right now, from June 1 to July 13th. And again, these dates are subject to change, but that's just where we're going to start in terms of this sign up.
Hello, if I might, this is Brenda Alford. I had a couple of questions. How many monitors are allowed on each shift? And also, what will be the specific duties of the monitors on site, please?
Hi, Brenda.
Hi.
Yes. So I will say that right now we are hoping that we could have 1 to 2 monitors for each shift. That is our hope. And so just given the size of the area, but also I think the length of time too. Right now, as we're looking at well over a month, Monday through Friday. So that is our hope. I think we start with 1 to 2 monitors, and we could go from there. Specifically in terms of responsibilities, really, I would frame it as the main roles of the cultural monitors is to really oversee what is happening throughout the process. Also consult in some of the decision making with the workers on site. But again, I think the big thing here is going to be just ensure that we are handling this with respect. But this goes, I think, throughout the whole process of the excavation. I think Carrie can speak more to the specifics of what will be happening. But I think overall that is our hope, that the cultural monitors just being a part of the process and being able to observe and be consulted throughout their time there.
All right, thank you so much.
Yes, ma'am.
And I can definitely follow up on that. And then Phoebe's going to also, I think, is going to also chime in as well. But Kevin, just to kind of go back a little bit to the earlier question that you pointed out. So the process of removing that, the overburden, that soil that was placed over the coffins after they were put into the grave. So you are correct that it will go quicker for the locations, the portions that we excavated back in October. When we get to the point of reopening those portions of the grave, that excavation process to remove that overburden will go quite quick because we know there's nothing in that overburden, right? And so we can more quickly get down to the level of being able to expose those burials that, of course, we left in place in October, that we just simply exposed but left in place. We may not, our plan at this point in time is to not necessarily start at that particular portion of the grave. We're probably going to start on the east end And this is basically because we're having to navigate the logistics of where we can set the heavy machinery and where we can then position the back dirt that as it gets pulled out. So at least initially, it'll be probably that slower process because we're going to be in kind of uncharted territory. We're going to be in a portion of the mass grave that we have not yet exposed. And so for the very first week, but our plan right now is to have just our principal crew that we've had up to this point in time, our main team, some of our main team members, be present during that first week when we break ground June 1st. So June 1st through June 4th, that Tuesday through Friday. We'll be working on getting that area exposed down to a level at which we have coffins ready to be hand excavated, so that when the consulting archaeology team comes in to assist with that excavation process, they can get right to work because they won't be coming in until the following week. And so then they would get right to work, and then incrementally, and as we're able to do so, once we get to an appropriate point in terms of the process of the exhumation of the remains in that first area, then we would move to another portion of the mass grave and expose remove the overburden there and get down to the level. So we'll have stages kind of happening, and so there's going to be quite a bit of different work happening. Some combination of people working on the exhumation process, the excavation and documentation and exhumation process. And then there's going to be a point where we're also then having people monitor the heavy machinery excavation on a different portion of the mass grave so that we can continue to make continual progress. So, and then Phoebe, I don't know if you want to add anything on that.
Sorry, I had to find the mute button. Yes, so I'm responding to Ms. Brenda's question about the duties of the Public Oversight Committee members, because we are exhuming remains this this time. I mean, this is a serious test, so I do hope that the Public Oversight Committee members on site will be able to escort the remains with the funeral director, walk them from the excavation site to our field laboratory. And I say that not knowing about the real physical distances and the actual outdoor temperatures at the time when we're doing this transport, but this will be our time for our solemn transport of these individuals to the field laboratory. So I would be very pleased if the Public Oversight Committee members could participate in it.
And I like to also encourage other members of the Public Oversight Committee to play a role in the monitoring. I know that some of us were out there, Brenda, myself, Chief, and Christy. We need everybody on board so the burden won't be so heavy upon us. It is a big responsibility because, like others have said, there are a number of things that can go on, and they seek our approval to do certain things. So we have to be there on point. So I'd like to encourage all the oversight members to please sign up and play a role in this because, hey, it's a part of history and it's new history for us. So be a part of history and then sign on up.
Thank you all.
Thank you. Good to see you, Miss Brenda.
Good to see you all as well. Thank you.
And hopefully maybe Miss Brenda and Kevin can attest to the fact, and even Greg Robinson has been out there as well, and Chief Amason. So we've had multiple people. We do try to make it as educational as possible. We let people know. We do tours of the site and talk through all the different things that we're doing and why we do things the way that we do it. And invite any kind of feedback that you have to offer while you're out there. Any questions that you have, we'll do our best to answer. And so it's, yeah, we really try and make it as much of a team approach as we possibly can.
Yeah, and I concur with that because I've learned so much by being out there. all that time and stuff like that, and being able to assist in the process. So that was something that was, for me and people that know me, that was a very important for me to be a part of the process. And those who feel about this situation, and most of you do, you will be blessed by being a part, whatever is done out there, because the whole world is watching us. And I would like to have, bragging rights that we were there, being a part of that process. And I like to just encourage her, because I really enjoyed it. It had me looking at those TV shows, what NCIS and all them TV shows. Like, no, that's not how you do it. That's fake, So I think I'm getting there to almost be an expert on most doctors.
And I will say that, I know it gets warm in July, but okay, I'm not inviting everyone to crowd into there, but the laboratory space will have air conditioning. So at least there'll be respite. And this is a chance to really visit with perhaps the bones of your ancestors. The relationships are unclear, but if you're an escort, you do need to be prepared to be around human remains, because this time we will be producing human remains. So, but it won't be scary. I take that back. It won't be very scary.
Be afraid, be very afraid. Do you think, Dr. Carey, that we have some kind of update as far as the Rolling Oaks situation? I have yet to get any kind of information exactly where the scan is going to be. I haven't got anything on that. So would it be by next meeting in June, or we're going to have a meeting in June where we get a little more detail as far as what is the agenda and what is the area, and where do we go from there as far as the Rolling Oaks?
Sure, I think we can definitely make that happen. And I apologize for not having that for this meeting tonight, but I think we can certainly make that happen, and we can circulate that information either in advance of the next meeting, or just make sure that it's discussed at the next meeting, and we can provide that information.
Just a reminder, the dates for that work are June 14th through 16th. So it'll be happening simultaneously with the work at Oaklawn Cemetery.
And just one more question. What will be the COVID regulations for anyone on site at this time? I know we had to take, basically take the test last time, but what will be those protocols this time, please?
So we're going to have a pre-work meeting with the contract archaeology firm, and we will invite, Chair Ross probably to participate in that as well. We're really adjusting based on updated CDC guidelines. But what we told all of our partners is we prefer vaccination. But if someone is unable to be vaccinated, that would not preclude them from participating. We would probably ask that you wear a mask. And we may actually be requiring everyone to wear PPE for different reasons while they're doing the work. So we'll provide more clarity on that point before people come into the field on June 1st.
Thank you.
Are there any other questions from the Public Oversight Committee? Okay, hearing none. If there are questions from the public, you can go ahead and put those in the chat. We'll do our best to answer those. And I've also put an email address in the chat for members of the media to direct their inquiries to communication, DEPT@cityoftulsa.org, and our communications team will follow up with any members of the media who have questions. Okay, Just so everyone's aware, while the City of Tulsa website is down, we're going to be placing a link to the video for tonight's meeting on our Facebook page. So if you want to watch the video or share the video, you can visit 1921 Graves on Facebook, and we'll have the meeting video there later this week. Chair Ross, do you want to close us out?
Well, I will say this in closing, and I will repeat what was said early on. Here we are on the brink of history, and I'm so glad that our team will be back together making good history, doing the right thing on our watch. And so, doctors, I'm awaiting anxiously on your return to Tulsa as we begin this road, this journey, this quest to right or wrong. And good luck for all of us and our efforts to make a difference in this world. And I thank you.
Well said. Thank you. Everyone have a good evening, and we look forward to seeing you this summer as we continue the work together.
Thank you, everyone. Bye.